For those that don't already know, I should say that Hong Kong is actually a common law jurisdiction. So for this reason, the judgments of the High Court are actually very, very important. So when a judge hands down a decision like this and essentially sets certain standards and principles that a message is being sent out to the market, then the bank should certainly take notice and study in detail the findings of the judge. Now, in this case, the investor, Mr. Li, made a claim against Standard Chartered Bank. Now, his cause of action there was two causes of action essentially. One was misrepresentation and the other was breach of duty of care by the bank, in other words, negligence. Now, as I said, the judge has essentially sent out a number of warning shots in this judgment. So the banks and other financial institutions, I think they're going to have to tread very, very carefully going forward. Now, in terms of their business of selling financial products, I think the banks are going to adapt perhaps the way in which they sell their products to retail clients. They're going to have to review their own procedures. Now, the question I suppose is, well, how do they do this to ensure that they don't fall foul of the law? Now, in my view, I think that banks, and certainly when they're selling financial products through investment advisors, the investment advisors are really going to have to take a much more sort of standoff approach and be certainly a lot less proactive when they're recommending particular financial products to the clients. Now, I suppose the question is, well, how do they actually do that in practice? I mean, they're all under a lot of pressure. They need to sell the products. That's how they make their commissions. So I think they just have to review carefully when they're presenting information on particular funds to clients, right? That they have to really avoid to be seen to be recommending a particular product to a client. I think that's the key message that came out from this judgment of Mr. Justice Chan. So often what happens in practice is the financial advisors receive information from the fund managers. Now, that usually comes in the form of some sort of fact sheet or update. Now, the tendency in practice is obviously the banks essentially just pass that on to the clients, and they may give their own opinions and recommendations on particular funds. So I think that the financial advisors, they just have to be very careful that when they're presenting that information, that they certainly don't show any bias towards any fund, and they make it clear that the information which has been given by the fund is information from the fund, and it is not information that the bank is giving from its own sources. I think the practical reality is that the investment advisors employed by the banks, they usually have a range of financial products that they're trying to offload, right, and get them off the shelf, so to speak. So what they have to be very careful is, and this was very, very clear from the judgment, is that the investment advisor has, where multiple financial products are being sold, the investment advisor's got to be very careful that he devotes the same time to each financial product. And when he's providing any analysis on a financial product, he has to spend the same time with the client with each product, so that when an outsider looks at the situation, they can see that the bank has taken a very, very neutral stance with the financial product, and it's not effectively promoting a particular product.